CNT, non-occupancy rates, that is section 38 to 42. Rate of rent shall be decided based on the agreement between non-occupancy rayat and the landlord. Non-occupancy rayat shall pay rent for his holding in the same way as applicable to an occupancy rayat. The rent of non-occupancy rayat shall not be enhanced except by registered agreement or by agreement under section 42 or section 40. Grounds on which non-occupancy rayat may be ejected is on the failure to pay rent for 2 years within 90 days after commencement of the third agricultural year, on using the land comprised in his holding in a manner that is not authorized, which materially impairs the value of the land. On breach of any of the terms of the contract between himself and his landlord, on expiry of the term of the lease where he has been admitted to occupation of land under the registered lease, on his refusal to agree to pay a fair rent. On refusal to agree to pay a fair and equitable rent, landlord shall make an application in the office of Deputy Commissioner for cancellation of the agreement. After hearing all the parties, the Deputy Commissioner shall decide on ejection or non-ejection of the Rayyat. Now, land exemption from provisions of Chapter 4 and Chapter 6. Payment of rent shall not apply to land acquired by government for any local authority or railway company, or land belonging to the government within a cantonment, or land used for roads, canals, embankment, dam, landlord's privileged lands, when they are leased out by an officer on a registered lease for a term exceeding 1 year, or on a written or oral lease for a period of 1 year or less. This is section 43. Now, lease and transfers of holding and tenures. Chapter 8, section 44 to 51. Every rayyat shall be entitled to receive his landlords a lease containing the particulars, namely the boundaries of the land comprising his holding, the amount of yearly rent payable for such land, and installments in which rent is to be paid if the rent is payable in kind, the proportion of produce to be delivered, and any special conditions of the lease. The landlord shall be entitled to receive a counterpart document in conformity with the terms of the lease. Restrictions on transfer of its rights by Rayyat. No transfer by a Rayyat of his rights in his holding or any portion thereof by mortgage or lease for any period which exceeds 5 years by sale, gift, or any other contract or agreement shall be valid to any extent, provided that a Rayyat may enter into a Bhugud Banda mortgage of his holding, or any portion thereof for any period less than 7 years, provided further that an occupancy Rayyat who is a member of any scheduled tribe may transfer with his previous sanction of the Deputy Commissioner his rights in his holding or a portion of his holding by sale, exchange, gift, or will to another person who is a member of the scheduled tribe and who is a resident within local limits of the area of the police station within which the holding is situated. An occupancy Rayyat who is a member of the scheduled caste or backward class may transfer with previous sanction of the Deputy Commissioner his rights in his holding or a portion of his holding by sale, exchange, gift, or lease to another person who is member of a scheduled caste or backward class who is a resident within the local limits of the district within which the holding is situated. An occupancy Rayyat may transfer his right in his holding or any portion thereof to a society or bank registered or deemed to be registered under the Bihar and Orissa Act of 1935 and owned by the state government or central government, or in which more than 51% of the share capital is held by the state government or central government or both combined, and which has been set up with a view to provide agricultural credit to cultivators. An occupancy Rayyat who is not a member of the scheduled tribe, scheduled caste, or backward classes may transfer his right or his holding or any portion thereof by sale, exchange, gift, will, mortgage, or otherwise to any other person. A transfer by a Rayyat of his rights in his holding or any portion thereof under subsection 1 shall be binding on the landlords. No transfer in contravention of subsection 1 shall be registered. In case of any stipulation is violated in any way, the Deputy Commissioner shall be a necessary party in all related suits in which one of the parties of the suits is a member of the scheduled tribes and the other party is not a member of the scheduled tribe. At any time within 3 years after the expiration of the period for which a Rayyat has been under clause A of subsection 1 transfer its rights in his holding or any portion thereof, the deputy commissioner shall, on the application of the Rayyat, put the Rayyat in possession of such holding or portion in the prescribed manner. The deputy commissioner may, on his own motion or on an application filed before him by an occupancy Rayyat who is member of the scheduled tribes for annulling of the transfer on the ground that the transfer was made in contravention of subsection 1A, holds an inquiry in the prescribed manner, provided that no such application shall be entertained by deputy commissioner unless it is filled by the occupancy tenant within a period of 12 years from the date of transfer of his holding or any portion thereof. However, before passing any order under the clause B or clause C of subsection, the deputy commissioner shall give the parties concerned a reasonable opportunity to be heard in the matter. If the deputy commissioner finds that there was no contravention of subsection 1A in making such transfer, he shall reject the application and may award such cost to the transferee to be paid by the transferor as per the circumstances of the case. If, after holding the inquiry referred in clause of the subsection, the deputy commissioner finds that such transfer was made in contravention of the subsection 1A, he shall annul the transfer or eject the transferee from such holding or portion thereof and put the transferor in possession thereof, provided that if the transferee has constructed any building or structure over such holding or portion thereof, the deputy commissioner shall, if the transferor is not willing to pay the value of the same, order the transferee to remove the same within a period of not exceeding 2 years from the date of order. However, where the deputy commissioner is satisfied that the transferee has constructed a building on such holding or portion thereof before the commencement of Chota Nagpur Tenancy Act 1969, he may, notwithstanding any other provisions of the Act, validate such transfer made in contravention of subsection 1A. If the transferee either makes available to the transferor an alternative holding or portion of a holding of equivalent value in the vicinity or pays adequate compensation to be determined by Deputy Commissioner for rehabilitation of the transferor. Nothing in this section shall affect the validity of any transfer of a Rayyat's right in holding or any portion thereof made bona fide before 1st January 1903 in the Chota Nagpur division except Manbhum area or before 1st of January 1909 within the Manbhum area. Now section 47, restriction on sale of Rayyat's right under the order of court. No order shall be passed by any court for the sale of rights of Rayyat in his holding or any portion thereof. However, any holding or portion of holding may be sold under the Bihar and Odisha Public Demands Recovery Act to recover an arrear for the rent or for the recovery of a loan granted by a nationalized bank, provided that if such holding or portion thereof belongs to a member of scheduled tribe or scheduled caste, it shall not be sold to any person who is not a member of the scheduled tribe or scheduled caste. Nothing in this section shall affect the right to execute a contract for sale of a holding registered before 1st of January 1903. Restrictions on the transfer of Bhuniyari tenure. A member of the Bhuniyari family may transfer any Bhuniyari tenure which is held by him or any portion thereof in the same manner and to the same extent as an aboriginal Rayyat may transfer his rights in his holding. The state government may make rules permitting a member of a Bhunyari family that holds any Bhunyari tenure to transfer such tenure or any portion thereof by sale, gift, exchange, or will. Save as provided in the two subsections above, transfer of Bunyari tenure to any portion thereof shall not be valid to any extent. If a member of Bunyari family transfers any such Bunyari tenure in contravention of the provisions, the Deputy Commissioner may, on his own motion or on application of such member, eject the transferee. A member of a Bunyari family who holds land in any village which a Bunyari tenure as defined in Chotanagpur Tenure Acts 1869 is situated may transfer such land in the same manner and the same extent as an occupancy Rayyat transfers his right in his holding under subsection 3 of section 46. Now, if any member of a Bunyari family transfer his Bunyari tenure or any portion thereof by a lease, and the lease shall not be acquired, the leasee shall not acquire the right of occupancy therein. No decree or order shall be passed at any court in respect of sale of a right in Bunyari tenure. Notwithstanding anything contained in section 46, 47, 48, any occupancy Rayyat or any member of a Bunyari family who is referred to in section 48 may transfer his holding or tenure or any part thereof for the following purposes: for use of land for any industrial purpose, for any other purpose which the state government may by notification declare to be a subsidiary thereto, or for access to land use. For use of land for purposes of mining or any other purposes which the state government may by notification declare the subsidiary thereto for access to land use. Every such transfer must be made by a registered deed. The state government may at any time within a period of 12 years from the date on which written consent is given by the Deputy Commissioner in regards to the transfer of any holding or part thereon belonging to an occupancy Rayyat who is a member of the scheduled tribes either on his own motion or by an application made to this behalf set aside such written consent. Now, acquisition of tenure or holding by landlords, notwithstanding anything contained in section 46 and 47, the Deputy Commissioner may on the application of landlord of a holding, authorize the purpose of acquisition thereof. The Deputy Commissioner may authorize the acquisition by landlords of such land or holding that has been declared by state government for the purpose of mining. The Deputy Commissioner shall, in addition to the market value of the land, award to the holder any interest of any interest acquired under this section, a sum of 20% on such market value in consideration of the compulsory nature of the acquisition. However, the Deputy Commissioner shall not be able to authorize the acquisition of any part of a holding whereon a temple, mosque, or any other place of worship, sacred grove, burial, or burning ground exists. Now, Section 51, acquisition of land shall be possible only after notice of transfer to the transferee after recipient of required payment after the acquisition. Now, general provisions as to rent, Section 52 to 63. A money rent payable under registered agreement shall be payable in 4 equal installments, failing due on last day of each quarter of the agricultural year. Payment of rent may be made at Mal Kacheri or at any such place where the rent of such land is usually payable by remittance using postal money orders. A tenant who makes a payment on account of rent or interest thereon, or both to his landlord, shall be entitled to obtain from the landlord a receipt for the same. A complaint may be made in the office of the Deputy Commissioner in event of landlord not providing the receipt. Any installment of rent not paid at the end of the year in which it falls due shall be liable to simple interest not exceeding 6.25% per annum. However, where rent is paid in full within the year following the year in which it occurs due, interest shall not exceed 3 years 3% on the yearly rent. A decision to cancel the lease of a tenure holder may be made in the event of non-payment of rent due, that is section 59. The rent of a tenancy shall be the first charge on the tenancy. However, if a tenancy is sold in the execution of a decree for arrears of rent, the purchaser shall acquire the tenancy free of all liabilities for rent of any period prior to the date of sale. Commutation of rent payable in kind. Where rent is agreed to be paid in kind, landlord may make an application to the Deputy Commissioner or Revenue Officer for the commutation of rent, money rent, and the Deputy Commissioner or Revenue Officer, after such inquiry as he thinks fit to make, may pass order for payment of rent as money rent determined by him. Where the rent of a